Yesterday morning, Senior Counsel for Tan Yi Peng and Srinivasan made submissions on his application for the Commissioner of Charities document or piece of communication that sparked off the CAD investigation into City Harvest Church. Citing a CAD press release that read, "The COC received complaints of misuse of church funds and informed the CAD when it assessed that some of these transactions needed to be investigated." Srinivasan told the court this communication from the COC to the CAD would constitute the first information report. The judge told Srinivasan he was quite sympathetic to the position the defense lawyer was in as far as the COC report was concerned. He clarified that he did not think Srinivasan was on a fishing expedition, as the prosecution had earlier accused, because Srinivasan was pointing to a specific piece of evidence that had been announced to the world at large in a press release from the Singapore Police Force. The judge eventually drew the conclusion that the report itself to the CAD, on the prima facie basis at least, appears to be relevant to these proceedings. The prosecution was then ordered to the investigating officer if he has a copy of this document. If the IO does not have the document, the prosecution will ask the Commissioner of Charities for it. At the onset of a cross-examination of Sharon Tan yesterday, DPP Mavis Chon pressed the finance manager on how the church's board meeting minutes were recorded and what those minutes contained. The DPP pointed out that the board meeting minutes were important because they were part of the documents the auditors relied on for the statutory audit fieldwork. In addition, the information in the board meeting minutes should be accurate, truthful, and transparent in reflecting what was discussed at each board meeting. Sharon Tan told the court that she would only capture key points of the board meeting and important decisions and approvals that were made by the board. Tan explained that some information, like the details of how the Extron bond proceeds were to be used, were discussed but not minuted down as the board wanted to remain discreet about the financing of the crossover project. The DPP charged that the real reason for not minuting down the purpose of the Extron bond proceeds was out of fear that the auditors would discover it to be a sham investment. Tan disagreed, stating that the auditors had access to both CHC and Extron books and would be privy to transactions between the two entities. Fung Dao Cheng, then managing director of the audit firm, would also have received information from the church's leaders. DPP Chon revisited the issue of the control CHC allegedly had over Extron and questioned Sharon Tan about how the directors of the events company were consulted on major decisions, suggesting that major decisions were made by the defendants instead. Tan, bringing context to a CAD statement, replied that while the aim was to make Extron a commercially viable company, it was not the sole aim of the directors. The directors Chung Ka Wing and Koh Xiao Ni were independent directors who shared the same vision and objectives as the church while having their own businesses. Having a common objective does not mean that the church made decisions on Extron finances. The prosecutor took the court through emails and documents that showed CHC's management reviewing salaries of Extron staff and deciding on bonus payouts. DPP Chon submitted that Extron directors would not make a decision, for example, on how much bonus to give until they have heard from CHC. Tan clarified that the 6 other organizations listed in the email would normally check with her on the direction the CHC was taking for the year-end disbursement of bonuses and salary adjustment. The other organizations would follow CHC's procedure as a guide if their own accounts permitted it, Tan explained. However, they could also have other figures or bonus schemes in mind that Tan might not be aware of. Ultimately, the directors made independent decisions for their respective organizations. DPP Chon continued to press her point, taking the court through emails, BlackBerry messages and spreadsheets in relation to the ARLA between CHC and Extron. Chon sought to establish that Extron's finances were treated as an extension of CHC and that the defendants were able to control and manipulate the flows of funds to Extron to eventually pay for the crossover project. Sharon Tan disagreed with the DPP's points. She clarified that the CHC board had known that the ARLA was set up so that Extron could redeem the bonds to CHC, invest in Ferna, and also to use the monies to bid for a building for the church. The court had heard earlier that this was done because auditor Sim Guan Singh had wanted the Extron bonds to be taken off the church's books. Tan further told the court that the CHC board was aware that should more funds be required for Extron to acquire additional shares in palm oil, the code name for Suntec, it was proposed to be done by extending the lease tenure of the ARLA. DPP Chon took Sharon Tan through her CAD statement where she said we should have consolidated the accounts of CHC and Extron and they would have fulfilled the disclosure obligation if they had done so. Tan explained that this answer, read within the context of the series of questions by the CAD interviewer, was in relation to previous questions the CAD had posed about the crossover project. Extron and CHC had the common objective of furthering the cause of the crossover project, but that did not mean that CHC or any of the defendants had full control over Extron. In addition, Tan told the court that if a strong line had been drawn that Extron and CHC are indeed related and that the books of both entities must be consolidated, the auditors who had access to both sets of accounts would have qualified the accounts of both Extron and the church. For more information, log on to citynews.sg. This is Wei Chung for City News Singapore.